For half a century, Uganda has been searching for an equitable law that governs domestic relations. The journey to have an equitable family law dates as far back as 1940s, when several women's organizations were involved in advocating for legal reform of laws governing domestic relations. These organizations included the Young Women's Christian Association, YWCA, Uganda Council for Women, Uganda African Women's League, Mothers Union, and Indian Women's Association, among others. By 1959, a private member's bill requesting government to inquire into the status of women generally and specifically on marriage, inheritance, divorce, and family property was tabled in Parliament. In January 1964, a commission was appointed headed by Honorable William Kalema with the mandate to consider the laws and customs regulating marriage, divorce, and the status of women in Uganda. The Commission's duty was to recommend laws that offered harmonious position between existing traditions and practices, but as well consistent with justice and morality of Uganda. The Commission report was produced in 1965, but no action followed thereafter due to the political turmoil in Uganda at the time. However, women organizations continue to agitate for the family law. It became necessary to split the Domestic Relations Bill in two: the Marriage and Divorce Bill to cater for Hindu, Bahai, Christian and customary marriages, and Administration of Muslim Personal Law Bill to cater for the Muslim marriages to allow agreeable areas of the bill to be passed fast, as women organizations and other human rights organizations in Uganda continue to push for a full family law. At the beginning of November 2009, the Uganda Law Reform Commission brought a new set of proposed gender-related laws before the Uganda Parliament for debate. Since then, Parliament has passed both the Domestic Violence Bill and the Anti-Female Genital Mutilation Bill. These laws now await the President's signature. However, a bone of contention remains on the proposed Marriage and Divorce Bill. It is against this background that UONET, in line with its mandate to advocate for gender-sensitive laws in Uganda with support from ActionAid Uganda, undertook a multidimensional approach to build a national consensus through a series of regional feedback and consensus-building dialogues in Luwero, Apache, Bundibujo, Kampala, and Tororo. The main objective of the regional feedback and consensus-building dialogues was to build consensus on the draft bills by promoting extensive stakeholder debate and participation in the development and formulation of a fair family law in Uganda.
Uganda Women's Network, in collaboration with ActionAid Uganda, under the Women Won't Wait campaign, embarked on regional consultations to ensure that people at the grassroots level input into the current bill. We've moved to regions holding consultative meetings with women organizations, opinion leaders, district leaders, religious leaders, and other civil society organizations. In light with that, we hope that the Marriage and Divorce Bill will be passed by the 8th Parliament before it is resolved. And we hope that the Marriage and Divorce Bill will complement other laws that have been passed by the 8th Parliament, namely the Domestic Violence Act and also the Trafficking in Persons Act, and now we are happy that even the anti-FGM law also has been passed.
The purpose of the Marriage and Divorce Bill is to reform and consolidate the laws relating to civil, Christian, Hindu, Bahai, and customary marriages, to provide for the types of recognized marriages in Uganda, marital rights and duties, separation and divorce, and the consequences thereof, and for the other connected matters. The Marriage and Divorce Bill is further aimed at addressing and streamlining the interests of all members of the family, both men and women, as a basis for creating stability and justice in the most basic unit of society, the family. The major purpose of the bill is to give effect to Article 31 of the Constitution, which states that men and women are entitled to equal rights at and in marriage, during marriage, and its dissolution. This human rights principle is being the overriding factor.
The domestic relations bill is now the marriage and divorce bill. What are people saying? Is it the truth? Do we actually know that we're talking about something that, stands the test of time? Or are we the hearsay? And that one really propelled, when I say something that is not truth, and everybody believes in me, all of us here will start selling the same idea, and yet it's not the truth. And we thought it would not be fair for us to continue with the type of rumors that go around the marriage and divorce bill. So we, as ONE, decided to have one national forum where we brought again civil society heads and people from the public service to come and understand what this bill is all about. So that while you and your constituency and the people that you serve, you give them the right information.
The specific objectives of the dialogues were to create awareness and understanding about the draft marriage and divorce bill, build consensus with key stakeholders on the provision of the draft bill, solicit support for the draft bill among actors, policymakers and implementers, provide information on and clarify the draft bill to stakeholders through this interactive fora, and facilitate through information sharing the passing of the draft bill into law.
There are so many bills that are being debated in Parliament, notably the domestic violence bill, the marriage and divorce bill, and we find that as we speak about them either in the media or any fraternity, there is confusion between the two. And we feel for us to make a meaningful contribution, we need to know the difference between the two. And it's the role of civil society and government to get people to know the difference between the two bills.
The bill protects the right to marry and defines the legally recognized marriages in Uganda. These include monogamous marriages. The bill provides for the essential requirements to marriage, which include consent to marry, and such consent must be given freely by both of the intending spouses. The bill states that marriage gifts are not an essential requirement for marriage, and where such gifts are given, it is an offense to demand for return of these marriage gifts.
This single bride price, you are trying to make sure, to discourage demand of it. But some people really demand it. And the problem I find, which we need to cure here, is that these churches, they demand for a consent of parents even when the children are above 18. Let it be clear here in this law that as long as the children are above 18, nobody should insist on this consent, because the churches, they will insist on consent when the poor young man is running away from the demand of these big bride price. So it should be sorted out, so that if they fail when the father demands too much, you go away with your girl but you be careful also, you need blessings.
The bill recognizes the conjugal rights of both spouses. The bill states that a spouse may deny the other spouse the right to sexual intercourse on reasonable grounds, which include poor health, surgery that affects the capacity to engage in sexual intercourse, childbirth, or reasonable fear that engaging in sexual intercourse is likely to cause physical or psychological injury or harm.
The problem is with the men. Because in our tradition, all the work is done by the women. And so a man comes up in the evening, when he has not done anything the whole day, he is very strong and is demanding for sex from a woman who is very tired. So there are some intricate things that we may not talk about, maybe we may not put into the law, but we may need to talk about them in our families and say, what are your obligations? Have you also done ABCD?
Throughout the entire dialogue, a clear message came across that unless the country has a just family law, development will be hard to achieve.
Going to your subject matter, we have been hearing of it, madam. That domestic relations bill, what have you, now you're changing the name to something else. But it has taken quite some time. I think it is for the better. When you rush a bill quickly, it will be passed through Parliament, and yet the population will not have known what it's all about. The implementation becomes a bit difficult because you have to now start with an ignorant population on that bill. They may not take it easily. But this one has taken time and people are talking about it. It gives time to people to know what is this bill all about. What is it that the women want to do? Women won't wait.
Time and again, the clan leaders are left out when new innovations like this one is surfacing. We are left out, and we are the first persons to be turned to and blamed. I'm grateful those who invited these participants thought of the clan leaders and brought me in. I want to thank you very, very much for that. But in most cases, the clan leaders are taken for granted. So if you don't know where you're going, you should know where you came from. Such that when a very, very important change is taking place, we, the parents, be also involved. Even if you don't want us to take very active part, just tell us, just for information. And because of this, we lack exposure to new things taking place. And then people go ahead and blame us and say the clan leaders or the culture are static. No, we are not static. I want to defend that. We are not static. For any change to take place, it must be gradual.
While the consensus is that Uganda urgently needs a just family law and the current marriage and divorce bill should be passed, activists are yet to win over the vital and influential constituency of religious leaders whose opposition to the bill stems from perception that the marriage and divorce bill in its current form encourages spouses to divorce. Yet according to the scriptures, marriage is for life. They argue that it provides grounds for parties to divorce, thus turning marriages into a commercial venture for amassing wealth. A major loophole in the current marriage and divorce bill is that it does not spell out a clear procedure for bringing matrimonial causes arising out of a customary law before a local council court. The procedure needs to be made clear so that both the courts and the parties married under custom law know their rights and responsibilities when proceeding under local council courts.
Issue of the local council. Either we are making the law satisfy the government, and since we know that LC courts are not even there, and men at local level 1, they are the ones who commit all these offenses, they are going to be conspirators in dealing with these matters. Are we really coming out with a law, really, which can be enforceable in our marriages here? We combine both Christian and customary, actually. But I see this thing is separating the two, and I think we've got to be very, very careful to see that we don't, the two continue to be done together harmoniously, like we've been doing. I haven't read the details of the specificity, but you be mindful of the fact that we do both. You go, they ask, you go, Quinjara, you come back, wedding, and that kind of thing. So we have to see how we harmonize the two.
Despite the existing gaps, the marriage and divorce bill is a step in the right direction, especially in as far as it seeks to give effect to the constitutional right of equality at and in marriage, during marriage, and at its dissolution. Also, as pointed out in Section 19 of the Constitution, the family is the natural and basic unit of society, and it is entitled to protection by society and the state. Part of this protection is through the enactment of laws that recognize and enhance the rights, duties, and responsibilities of husbands and wives.
We've been getting really difficulties for women to open up because actually there was no law and they were just fearing to be defeated. After taking the case, they opened the constitution, but this one says like this. Which case are you reporting? So women have been hiding the cases, but because of this, I feel they will open up.
Actually, we the ladies are living right now in fear because the men right now know that we are very, very dangerous. I would like to find out, in comparison to this domestic violence bill being passed, what Dralu should have done to protect herself. Because I have a feeling that maybe it was not the first time they were having this kind of problem. And maybe somehow, somewhere, she would have maybe used some of these, protection orders to take care of herself. So maybe as a lawyer, maybe you may guide us and tell us what you would have done or what you would have done.
But the fact of the matter is that we should not force people to stay together when things have failed. That is the reason why people kill each other every day. That is the reason why people hire other people to kill others. That is the reason. There are so many reasons why there are deaths relating to marriage. So if people feel they cannot maintain, if they feel that things have, and that is why we say irretrievable breakdown of marriage. So you have to show the conditions that have caused you to fail to stay together and convince court. It is not that everybody who applies will be granted. In some cases it is denied if they see that it is a flimsy reason. That is why they also give you 2 years to make sure that you have tried every solution. That is why they will also send you back and say, why don't you try mediation and counseling? Why don't you consider, there's a provision that says you have to consider issues of mediation and counseling. So it is not the case that you just walk into a court and you're granted divorce. No. You have to show, you have to prove illustrate many circumstances, and also it's not always a given. The judicial officers consider and see where it is necessary, they will grant it. Where it is not necessary, they will grant it. And also, there are options of separation. It is not always that you will start with a divorce. No. In some cases, they may advise you, no, it's better, you get a separation and see. And even when you apply for divorce, there's a 6-month period between when you apply and when it is actually given, because it is called a